Hey friends, welcome to Legal Learning. So today in this video I'm going to deal with section 154 of CrPC, which is included under chapter 12. Chapter 12 deals with section 154 to 176, and so I'll be covering the Barrett 154. Along with this, I'll try to link it with some other IPC sections as well, and I'll try to give you a very broad perspective. So let's begin. And chapter 12 is very important from both preliminary and mains perspective, and section 154 is also very important. Apart from this, the provisions dealing with arrest, section 41 to 60A of CrPC is also very important. It's also important, and another definition clauses under CrPC is also important for prelims. Plus, someone warrant is important, you know, but proclamations 84, 82. Proclamation is important. Then 1991 charge warrant, these provisions are also very important. Okay, and then section 125 maintenance, this is also very important. Okay, so first of all we're going to deal with 154 in this video only. Okay, now here you see section 2C. So you need to know the definition section, because in prelims question will be asked from definitions as well. So 2C deals with the definition of cognizable offense, and 2L deals with the definition of non-cognizable offense. Non-cognizable is something that is not serious, and cognizable, you know, it is something that is serious kind of offense. Further, in schedule 1 of CrPC, there's some columns, okay, and the column provides the kind of offenses: bailable, non-bailable, cognizable, non-cognizable, triable by which magistrate. So you need to see the columns in the Barrett as well. Okay, now let's see the heading here. Information to the police and their powers to investigate. So here one need to give the information to the police. Anyone can give information, you, me, or anyone. If any offense is being committed in some of your neighbor's house, then you can be also informant. You can also go to the police station and register a case, right? Anyone can put this criminal law into motion. So let's read it through history. Suppose there is some offense being committed. The offense is serious in its nature, like section 375 of IPC. Suppose, I'm just supposing it. Now after the offense being committed, any information you received here, now first what you need to do, you need to go to the police station. The police station which says the jurisdiction, obviously. So yeah, there's a concept of zero FIR as well. So this is I think we should not divert our topic. So 154. Information 154 relates to information only in cases of cognizable cases only, not non-cognizable cases. So every information relating to the commission of a cognizable offense, if there is any information, if given orally, that means you can go to the police station and you can orally say to the officer in charge of police station that some offense has been committed, or you can give it in writing as well, orally or in writing. There are two modes. In older days, I think when IPC, 1973, okay, it was the time. So I think there was some oral thing was there, but at present written. Okay, the best document is something that is written, documentary evidence. It should be, it may be in orally or it may be in writing. If it is in orally, then the officer in charge of police station shall reduce the same into writing by him or under his direction. Either he shall write it or he will say someone else to write it under his direction, and be read over to the informant. And what they wrote, they should read over this to you. Be read over to the informant. Informant may be anyone, like victim or victim's family, guardian, neighbor, anyone can be informant. Okay, and every such information, whether given in writing or reduced to writing. Given in writing, it might be given in writing, so that cases it they need not reduce it to in writing or all those kind of things, or reduced to writing as aforesaid will be signed by the person giving it, signed, so your signature is needed. Then or and the substance thereof shall be entered in a book. And the substance means the factual situation, what happened in that case, who did what. You just need to in this FIR you just need to write only the facts, whatever happened, who did what, all those kind of things, right? And it should be like there should not be delay in lodging FIR. Generally there should not be delay in lodging FIR. So substance thereof shall be entered in a book. This book is 172. Section 172 provides for police diary. So the police will enter everything in its diary, and the substance of the information, the police shall enter the substance of the information in a book to be kept by chas officer. In chas form, that means the form of the diary is the state government. Police is Schedule 7. In Schedule 7 of the Constitution of India, there are 3 lists: union list, state list, and concurrent list. And police is a state subject. So state government may prescribe in this behalf. So state government may make some prescriptions like notification in the official gazette and all those kind of things, right? You would see in COVID cases also there's many notification, right? This is a notification in official gazette. Okay, so now we need to note here provision to section 154. Provision to section 154. What it says? The provision was inserted by Act number 13 of 2013. This is Criminal Law Amendment Act 2013. There were 2 major amendments, recent amendments. One is 2013 and another is 2018. These 2 major amendments are very important. With effect from 3 to 2013. Okay, so the provision was inserted by Criminal Law Amendment Act 2013 in the year 2013, obviously. So let's read the provision. 2013. Provided that if the information is given by the woman against whom any offence under section 326A, 326B. So section 326A and 326B of IPC deals with throwing acid and attempting to throw acid. Okay, so these are inserted by Amendment Act because due to acid attack, like these 2 deals with acid attack provisions. Then 354, 354A, 354C, 354D. These are mainly related to A, B, C, D, voyeurism, stalking, and all those kind of things, right? And 376, it is like rape. And 376A, this all are rape. 376A, B, B, C, 376D, DA, DB. These are provisions relating to rape. Rape under authority, in police custody, gang rape, so like habitual offender. So section or 509, outraging the modesty of a woman. So these are all sections relating to women. Of the Indian Penal Code 45 of 1860, alleged to have been committed. Allegation is there. That means committed or attempted. It includes both commission and attempt. There are I'm showing you. There are certain things you need to note. One is commission of the offence. Another is attempt. Another is abatement. Another is conspiracy. Commission, attempt, abatement, conspiracy. These 4 things are very important. Attempt is something that you're going to commit a crime but you fell short of committing it. Abatement is instigation. The provisions relating to abatement is provided under section 107 to 120 of IPC. Abatement might be by instigation, conspiracy, and intentional aiding. Then abatement. Instigate means provokes someone to do something, and conspiracy 120A and 120B of IPC. Okay, and attempt section 3. Attempts are like section 307 deals with attempt to murder. Okay, section 308 deals with attempt to commit culpable homicide. One is murder, another is culpable homicide. Section 309 deals with attempt to commit suicide. These are attempt sections. Apart from this, section 305 deals with abatement, of suicide of a child or insane person. Section 306 deals with abatement of suicide, normal, 18 plus, major, and it is child and unsound person. So these two are provisions relating to abatement. And commission of offense, I'm just giving it an example to make you understand the thing, okay. And the commission is under 299, commission 300, commission of 299 commission of culpable homicide. Section 300 is commission of what? Commission of murder. Then punishment is provided under section 304 for culpable homicide, and for murder section 302. And section 301 is very important section under IPC. They might ask you MCQ regarding it, because it deals with like punishment for murder by life convict. Suppose you're committing murder not you. Suppose Mr. A is committing murder of Mr. B, and after committing murder he was sentenced to imprisonment for life. So inside the prison he again committed another murder. So that's what deal with section 301. These kind of sections are very important, okay. So they might ask questions regarding this. Okay, and apart from this, I'm gonna make two sections clear. One is section, which one? One is section 326 and 326B. As you know, section 319 deals with hurt, simple hurt, definition only, okay. Section 320 deals with grievous hurt, definition. Section 326A deals with voluntarily causing hurt, by use of acid. 326A, voluntarily causing hurt by use of acid, okay. And section 326B deals with either throwing, that means commission itself, or attempting to throw, that means attempt, commission and attempt both, throwing and attempting to throw acid. Okay, so this two relates to acid and hurt. Then comes section 354. 354 deals with assault or criminal force to woman with intent to outrage her modesty. So assault and criminal force, okay. And definition of assault and criminal force are given under definition of criminal force is 350, assault 351, okay. And 352 punishment for assault or criminal force, otherwise than on grave provocation. And 353 is something relating to public servant. So 354 is mainly relating to assault or criminal force, both assault plus criminal force, okay. 350 plus 351, assault and criminal force to women. Particularly this offense, this provision relates to offenses relating to women. To women with intent. Intention is there. You know, intention is very important in criminal law, which is called mens rea, malafide intention, to outrage her modesty. And when it comes to her modesty, then it's a serious kind of offense, some sort of serious, obviously. Then comes section 354A, which deals with sexual harassment and punishment for sexual harassment. It deals with both the harassment as well as punishment. In the same section, punishment is also provided. So sexual harassment, SA, okay, 354A, SA, sexual harassment. And then 354B is assault or use of criminal force to women with intent to disrobe. Okay, assault and criminal force is there in 354B as well. Then 354C is voyeurism. Voyeurism means some woman is taking, suppose some woman is a woman is taking shower and someone is looking at her, I mean from some window or some other ways. So it is called voyeurism. And stalking in it might be in social media. Someone is stalking you, someone is tracking you, where you are going and what are you doing. So this is called stalking. It deals with section 357. So this is important in today's time, I mean. Then section 376, again the provisions relating to rape, okay. So definition is provided under section 375. 376 deals with punishment for rape. 376A, there is a case law is also there, is 376A, okay. I forget case law. If I remember, then I'll write down it in the comment section. Which is punishment for causing death or resulting in persistent vegetative state of victim. Vegetative state means something like coma, some sort of like that, brain dead or something like that. So it's a serious, it's extremely serious. Then 376 AB is about what? Sexual intercourse by husband. Sexual intercourse by A and B. Okay, sexual intercourse by husband upon his wife. It's okay if they have sexual intercourse, but if they are having that shown during separation, that's something offense. I mean, okay, not 376C, sexual intercourse by a person in authority. Sorry, 376C, sexual intercourse by a person in authority. Person in authority. Someone is in your authority. For example, your employer. Okay, he's person in authority. And also it includes remand house. So if you read the section, you will get to know what's given here. And D, gang rape. Then E, punishment for repeated offenders. So in case in those offenses, such information shall be recorded by a woman police officer. Then second proviso, provided further means it is second proviso. Okay, rules of interpretation. In the event of the person against whom an offence under this section, as we have already read, is alleged to have been committed and attempted, is temporarily or permanently, mentally or physically, it may be temporal permanent TP, it may be mental and physical MP, disabled. The person is disabled, I mean the woman is disabled. Then such information shall be recorded by a police officer. Pick the word residence of the person seeking to, okay, and any other convenient place, resident as well as convenient place. Residence in any convenient place, okay, in the presence of an interpreter and special educator, not an but or, anyone or special educator. Then recording of such information shall be videographed, video, okay. And C, the police officer shall get the statement of the person recorded by a judicial magistrate under clause A of subsection 5A of section 164. When we'll read section 164, 5A, section 164, subsection 5A, clause A. Then we'll read it, we'll discuss about it. Okay, I can discuss about it right now even, but I'm not gonna do because the video is getting very long, going very long. And the copy thereof shall be given free of cost to the informant. Free of cost, okay? No money charge, no money, free. Okay. And any person refusal on the part of police officer in charge of police station, any person, if the officer in charge of police station refuses to register your FIR, then you may send the substance of the information in writing and by post to the SP, Superintendents of Police concerned, if satisfied that the information discloses the commission of a cognizable offence. And the SP shall investigate the case himself or direct an investigations to be made by the police officer subordinate to him in the manner provided by this code. Okay, done. So thanks for watching. If you like my videos, please do not forget to share, subscribe, like, comment and share. Thanks for watching.